Okay, so I hope you can all see my screen, and I'm going to proceed. So until 21st of September 2022, South Africa's Copyright Act did not provide for accessible format shifting. And a lot of you might know what that is, but some of you might not know what that is. So let me explain what's going on. So what is format shifting? If I wanted to read a book, I could go and buy it from my local bookshop or borrow it from my local library or the WITS library and read it immediately. The only step that I would need to do is actually go to the library to borrow it, or go to the shop to buy it, or even download it onto my computer. But the situation is quite different for people living with disabilities. There is an additional step of conversion that is required, and that is what we call format shifting. That additional step of conversion could look anything like converting a book that you buy from the shop into Braille for people with visual and print disabilities to read. Alternatively, scanning it and scanning the print copy of a book or a journal article, a physical journal article or a physical newspaper article, from print to digital, so that screen readers can actually read this out loud, etc. But until the 21st of September 2022, the Copyright Act did not allow for this conversion process to take place. So you might ask, what then did reading look like for someone with visual and print disabilities until that time, until last year? And to understand what that looked like, we must first understand what the Copyright Act says and what it did and did not do. So copyright scheme is fairly straightforward. The 1978 Copyright Act sets out a bundle of rights, and essentially copyright functions as a statutory monopoly over the use of literary, artistic, dramatic, cinematographic, etc. works. So you can think of them as cultural works in general. So when I say use of works, I mean things like publishing the work, reproducing or copying the work, adapting the work, performing the work, translating it into different languages, etc. But control over the use of these works, as I just described, is statutorily vested in the author initially, at the first instance, or creators. And what that means, so there are two types of rights that are vested in the author or creator. So the first set of rights are moral rights, which essentially mean that authors and creators have the right of attribution. That is, they have the right to always claim that they are the author of the work that they have authored. And they also have a right to the integrity of the work. They have a right to claim that that particular work must not be mutilated in any form. There's also another set of rights called material rights, which are more economic in nature. And those are the ones that are usually licensed to publishers and other intermediaries. Now, that's what I mean by the creative industry. So the rise of the creative industry entails then that publishers and other intermediaries, they contract with creators to disseminate their works. And it's usually the economic rights that are then licensed. Common practice is either for a transfer of copyright or a license to publish, adapt, translate, or otherwise use the work across jurisdictions or in specific jurisdictions. Crucially here, the copyright holder has to authorize the use of a work in a particular type of use of the work. And unauthorized uses, that is, uses that are not provided for also by the law, are termed as infringements. So there are two types of so for example, if I, as an author of a journal article, authorize you to use the work, provide you with permission to do that, that's great, provided that I hold the copyright and I have not transferred it to the journal. And second, if in law there's an exception to this authorization requirement that says that anyone can use it without asking me for authorization, say, for example, for educational purposes, or a library for preservation purposes, then that's not an infringement. But any other use would be termed an infringement. And infringing uses are subject to civil and criminal penalties in the Copyright Act. So going back now to accessible format shifting. When there's no explicit provision for accessible format shifting, this particular act of conversion that I described becomes subject to civil and criminal penalties. And this is what Blind Essays campaign across the past 2 years has been the hashtag Braille is not a crime or Braille is no crime. It's for this is what they mean by that. So for example, let's say a person with visual and print disabilities purchases or borrows a book, just like in the example I gave you before. In order to read that book, they must first find out who the copyright holder is. If it is the author, find the author's contact details. If it is the publisher, find the publisher's contact details and ask them for authorization to convert that particular print book into a format that they can read. So that is the first step. The second step is to actually contact them, the copyright holder. The copyright holder has no obligation to publish their details online or anywhere accessible. Additionally, they have no obligation to respond. So, but even if let's imagine that they do respond, let's imagine that we get through these first few hurdles, they must be requested by the person who wishes to convert, the person who wishes to exercise their right to read. They must be requested to authorize the scanning of the book and or reprinting it through a Braille printer and or processing it through a screen reader. Now, if they don't respond, then that particular person who seeks to convert is barred from reading the book entirely, or will do so, but opens themselves up to possibly criminal sanction because it would be an unauthorized use of the work. Now, this was the situation until 21st of September, 2022. This is also generally known as the book famine, which essentially is a term that the World Intellectual Property Organization has also used. In 2016, WIPO, as I'll call them, found that approximately 285 million people live with visual and print disabilities globally, but less than 7% of books are published in a format that's actually accessible to them. This is what is known as the book famine. And I've described how copyright acts as a barrier there. Now, obviously, copyright is not the only barrier. There are many other barriers. For example, publishers, universal publishers can move towards universal design and set standards and guidelines towards publishing works that are born accessible. But this has not been reflected so far in the practices of the publishing industry locally in South Africa. Now, out of this book famine arises the Marrakesh Treaty to facilitate access to works for people who are visually impaired. And Caroline will talk more about the Marrakesh Treaty, what it essentially, and what it does, etc. It is important to note at the same time that South Africa is already party to the United Nations Convention on the Rights of Persons with Disabilities. And that means that South Africa undertakes obligations under that. And one of those obligations is to ensure that intellectual property laws do not act as a barrier to participating in cultural life for people with all disabilities, not just visual and print disabilities. Let's now turn quickly to the Copyright Amendment Bill, which has been in Parliament for approximately the past 15 years. The current version of the bill that we're looking at is titled B13F 2017, but at the time of the litigation and the court case that I'm going to talk about was B13B. So if you are planning to look at the judgment alongside, then just note that it's different now. The first time we saw disability-related provisions in the Copyright Amendment Bill was in 2015, and that then morphed into Section 19D, which again, Caroline will talk a little bit more about. Essentially, Section 19D contains a clear provision stating that people with disabilities and people assisting people with disabilities can shift formats, and that will not be an infringing act. In any event, there was a long history of the current copyright reform process. I don't have much time to go through that because I want to really just quickly take you through the judgment before I hand over to Caroline. I suppose a potted history of that would be that Blind SA in 2020, which is an NGO that advocates for the rights of people with visual and print disabilities, they litigated way back in 2020 because what happened was the Copyright Amendment Bill went through both houses of Parliament and was passed in 2019. And then it sat on the president's desk for approximately 16 months. And at that stage, the president was just sitting on it. He didn't sign, or he didn't send it back. So Blind SA then litigated to compel the president to act, to make a decision. And then the president sent the bill back to Parliament and set out certain constitutional reservations that he had. The bill then went through a whole process to address those reservations. And Blind SA litigated once again in 2021. And that is the judgment that we're talking about today, the 21 September 2022 judgment, because it takes that time to get through court. And essentially what Blind SA's concern was that their rights to equality and dignity particularly were being violated because of what I just described to you. And their rights to access education, participate in cultural life, and their freedom of expression and ability and sort of freedom to impart and receive information was also violated by the current Copyright Act and the lack of an accessible format shifting provision in the Act. So the aftermath of that litigation, and I'll tell you what the Constitutional Court held, etc. In the aftermath of that litigation, we can see that Parliament has actually taken into account the judgment and made certain changes to the Copyright Amendment Bill to align it better with the judgment, which is an interesting instance of government working together, even though courts had to be triggered by Blind SA, etc. So first, the matter went to the Pretoria High Court. It was unopposed. And then because it was a judgment relating to constitutional invalidity, it went to the Constitutional Court. In the Constitutional Court, as I said, Blind SA were the applicants. The respondents were the Ministry of Trade, Industry and Competition, Ministry of International Relations and Cooperation, the President and Parliament. And there were 3 amici curiae who also made submissions. Blind SA's affidavits consisted of 4 deponents: the head of Blind SA, a former Constitutional Court judge, a novelist, PhD researcher, and a school teacher. The matter remained unopposed. The parties to the matter agreed that the Copyright Act unfairly discriminates against people with visual and print disabilities, and they also agreed that it was unconstitutional in that regard. Now, the court unanimously recognized that it was common ground amongst all parties that there was drastically restricted access to published works for people with visual and print disabilities, and that this constituted unfair discrimination. Importantly, the court made clear that the effect of the copyright holder not being contactable was exactly the same as the effect of the copyright holder declining a request for authorization. So essentially, we found that the unfair discrimination analysis all centered around this requirement of authorization. And Caroline will talk a little bit more about what the Marrakesh VIP Treaty does in that regard. So just very quickly, I've got perhaps another 3 minutes. The Constitution, with regard to the unfair discrimination analysis for the lawyers in the room, the court applied a sort of truncated version of the Harkson test. It asked, does the provision differentiate between people or categories of people? It then found that the differentiation did not bear any rational connection to any legitimate government purpose. And in any event, this differentiation did amount to discrimination on a specified ground in the Constitution, that is disability. And so it also found that it has the potential to impair fundamental human dignity of people with visual and print disabilities as human beings. And so what the court did was an instance of reasonable accommodation. It basically, and I've put that at the second bullet point, you can see that's at paragraph 68 of the judgment, provides different treatment to secure non-discriminatory outcomes for all. It wasn't just discrimination, though. The court also held that, as I said, the right to dignity, freedom to receive and impart information, participation in cultural life, and the right to education were all violated by this requirement of authorization that existed for people with visual and print disabilities, but did not exist for people without visual and print disabilities who were able to access the market or able to access a library, etc. As I said, the ruling turns on the requirement of authorization. The scope of the judgment, though, was limited to literary and artistic works and to people with visual and print disabilities, because the court mentioned that that was the case before it. This does not mean that it cannot extend to people with other disabilities. In fact, it does. Section 19D in the current version of the Copyright Amendment Bill does extend it to people with other disabilities, and this is in line with South Africa's obligations under the UNCRPD, as I mentioned before. Most recently at the World Intellectual Property Organization, the African group's proposal was accepted that research must be started for a new treaty on people with other disabilities as well, and the extent to which copyright acts as a barrier for people with other disabilities as well. So really, this would just be ensuring that South Africa's laws ensure that they fulfill the obligations that the state already has, as well as look to the future. Of course, the judgment is a win for people with disabilities, and it forces us to ask a question. To what extent is copyright's fixity itself compatible with the UNCRPD's commitment to accessibility and universal design? But I won't go into that now. That's a question for another day. Let's look very quickly at the remedy, and then I'm going to hand over to Caroline. This is my last slide. So the court held all of those things that I described. Two important things to note about the remedy. The first is that the order of invalidity, that is of unconstitutionality of the Copyright Act, was suspended by the court for a period of 2 years. And the court then crafted its own remedy, which it then read into the current Copyright Act, fixed this unconstitutionality in the interim period. Because what it did was recognize that Parliament is proceeding with this ongoing process of copyright reform and the Copyright Amendment Bill. So these 2 years acts as a deadline for Parliament, essentially. And we only have 10 months before the deadline arrives. The second thing to note about the remedy is this, that the court had two options before it. They had the then Section 19D that Blind SA had proposed that the court read in with modifications to ensure that that particular provision was immediately operational and did not require regulations, which would further then delay the process. And the second proposal before the court was one of the amici's proposal, which is Owen Dean's proposal, that was to direct the minister to promulgate regulations. And the court essentially held that for various reasons, both of those proposals, it would not opt to adopt either of those proposals. It basically said that people with visual and print disabilities should not have to wait any longer. Immediate redress is required. And also that regulations are limited to reproduction uses only because of the enabling section, and does not include any other uses. But accessible format shifting requires more than just reproduction. And it crafted its own remedy, Section 13A, that it read into the Act. So I'm going to stop there. And I'm going to invite Caroline to now continue with a further discussion on the remedies and on the Marrakesh VIP Treaty. Caroline, over to you.
Thank you, Sanya. I'm just going to do the usual, try and share my screen. So just a minute, please. Great. I'm sure you can see my screen now. So thank you for leading us in, and welcome to everyone. It's good to be in the same virtual room as you. I am going to try and not speak for too long, because I'm sure that many of you have got some inputs, have some ideas, and so I will try and keep it short. There will be some overlap between what Sanya has said and what I will talk about, but I'll try and make the distinctions that I am seeking to really focus on. So as you heard, I'm going to speak about the remedy, what the court gave us. And I wanted to take a few steps back, if you will, and talk about the setting, try and locate this remedy within the larger picture, because I think it's really important for understanding of the remedy, for us to be able to place the remedy in its rightful place and its rightful context, and then we can understand its implications. So you already heard from Sanya, and I'm sure you know already, that there is a global approach to securing access for persons with disabilities. That comes out from what I'll refer to as the CRPD, the Convention for the Rights of Persons with Disabilities. And I've chosen to use two terms today. I'm going to use the word broad. I'm also going to use the word narrow. I do not intend to impart any negative connotations to either of those words. They're just descriptors. When I say broad, I'm talking about access for all disabilities. When I say narrow, I'm talking about access for a subset of disability. Neither of them is bad, right? It's just a tool that I use. So I wanted to say that at the global level, we know from the CRPD that the approach is broad. And I'll show you the provision, and Sanya spoke about it a bit. Now, because that's quite a huge vision to fulfill, what has then happened is that we have a phased global approach. So although the goal is to secure access for persons with all disabilities, you eat an elephant one bite at a time. So there's a staged approach, if you like, and the first stage that has been successfully completed, in my view, would be for provision for persons with visual and print disabilities. This is the miracle of Marrakesh, right? Miraculous because it's the first treaty ever that is focused solely on exceptions and limitations. The second stage, as Sanya has just told you, continues at WIPO, at the Standing Committee for Copyright and Related Rights. And so there you heard also that this March, the African group successfully had a work proposal approved by the group. And so all WIPO member states sit in here. They've all agreed that they will continue to look at how access can be secured for other disabilities. Sanya mentioned some research that's going on. I've been very privileged to have been participating in that research since 2017, looking at some of the approaches taken nationally by states, WIPO member states. And so this is the note that I'm making here to say, although the global approach has been phased, we've completed phase 1, we're working on phase 2, but several individual WIPO member states have already gone ahead and provided for other disabilities. So it's staged, if you like, at the global level in terms of coming up with binding international agreements, but at the national level, it is not phased in that sense. Member states are moving ahead, and South Africa is also trying to move ahead. So this slide talks about, it just shows you the text. If you're keen to see, where to find the broad approach in the CRPD, there you have it. You have Article 1 that talks about all disabilities. And then you've got Article 33, which then talks about the fact that intellectual property laws should not constitute barriers. I underlined intellectual property because it's not just copyright, it's actually all intellectual property. But remember, I said phased or gradual approach. And so we've started with copyright. So where does the Marrakesh Treaty come into this? It comes in as a toolkit. So it is for stage 1, and it is the toolkit that is being used to implement the first stage. It's a binding international agreement. So what is South Africa doing? South Africa has adopted a fused national approach. By fused, I mean South Africa is trying to keep up with the global approach to take a broad view to cater for all disabilities, but at the same time, it is using the Marrakesh toolkit, which is from stage 1, which is the narrow approach. And that's why I say fused. South Africa has fused the broad approach and the narrow approach, right? So it has subsumed the narrow into the broad, if that makes any sense. Just stop me if you want me to explain, but maybe we can raise it later on. I can see there's a note in the chat, but I actually can't read at the moment, so I'll just keep going. What this slide then does is to show you in the CAB where you actually find text that attests to this broad approach. So you see at the bottom here the definition of a person with a disability. It's all disabilities, looks very similar to the definition that we have in the International Convention, by which South Africa is already bound. South Africa is bound by this treaty. This treaty has been in force for very many years. Right. So the remedy, where does the remedy fit in? The remedy fits in, remember, South Africa is taking this fused national approach, trying to do the global, broad thing, cater for all disabilities, but also ensure that it is in a position to ratify the narrow toolkit, the narrow tool, right? So we know already that the case enters into this stage. So the scope of the remedy then is limited by the case itself. The case itself, its scope is only for visual and print disabilities and for literary works with artistic works that are included in those literary works. So the case, the blind essay case then on all fours would be aligned with the first phase of the global approach. But always remember, it's within the fused enterprise that the state has decided to take. You've heard about the options, so I don't need to repeat that. Sanya spoke about two. I say three because the third one is the courts on a specially crafted way, but that's what I want to spend the next 5 to 7 minutes talking about. I've made a note at the beginning there. I'll pick this note up later on. And really the thought I wanted to plant in your heads is if the court, the Constitutional Court, did certain things in its specially crafted option 3, new section 13A. What does that mean for South Africa's fused approach? What does that mean for the narrow within the broad? What does that mean for Marrakesh within CRPD? Okay, so that's a thought. The answer, to show my hand already, it does not stop that. There's no adverse finding against the broad approach, but I will try and explain how I get there. So the other thing I wanted to very quickly do, and I'm sorry we don't have enough time to really dive into Marrakesh, but I wanted to say to you, Marrakesh is a toolkit. It is a binding international agreement, but South Africa is not yet bound. As you know, South Africa intends to join, but South Africa has decided that they want to get their house in order first by getting the legislation aligned and then ratify later. So what is this toolkit? What is this aspirational stage one approach, if you like? So Marrakesh takes this approach, first of all, to identify the role players in the ecosystem of making accessible format copies. So it speaks of beneficiary persons, it speaks of authorized entities, and then it sets out things, exceptions that should be contained in national legislation of those states who are bound by the treaty. So that's a mandatory or compulsory exceptions. And then it goes a further mile by saying you can have these optional ones, and then it actually suggests some text. However, this is a toolkit and it is not a straitjacket. Excuse my metaphors this afternoon. But when Marrakesh puts forward this text for the mandatory or for the optional exceptions, it reaffirms repeatedly that it is the option of contracting states whether they want to copy and paste the language of Marrakesh or whether they want to change the language and use something that's more suitable for their own setting. And so there are 2 slides here that I'm not going to really speak to, but I wanted to flash them at you, if you will, just to see what the mandatory exceptions look like. So bound parties are required to have a limitation exception that deals with reproduction, distribution, and making available to the public. And then there are others that pertain to importing or cross-border exchange. And this is really important because then it allows stakeholders to actually leverage off the efficiencies of others. So if you just have a provision that confines you to making these copies only within your space and you're not able to bring them in, that's quite constraining. It would be very useful if the borders were open, to use another metaphor, to allow the accessible format copies to be shared and thus to be more efficient in that. And yeah, if there are technological protection measures that have been applied to a work, digital locks to works, Marrakesh requires in Article 7 that national law makes sure that the protection or anti-circumvention provisions then do not create another barrier for accessing these works. So I've gone really fast through this, but these are the mandatory exceptions. And this slide that I'm just flashing at you is just an instance of where Marrakesh, it's one of several instances where Marrakesh repeats that there are options. States can use this language, can use different language, can use other means to make sure that these exceptions and limitations are available within their jurisdictions. Marrakesh also does not stop states from enacting other exceptions and limitations for other disabilities, for other works. It is a floor and not a ceiling, another favorite metaphor that I like to use. So states can go beyond Marrakesh, and many have. And the study I spoke about earlier, looking at WIPO member states in 2017 to 2019, showed that quite a significant portion of them already did go beyond Marrakesh. But anyway, a lot of background. So remember now, I was trying to build up to section 13A, the remedy that the court gifted us with. And the idea, I hope I've imparted clearly enough, is that it is within the context of a fused national approach that tries to merge the state's obligations to fulfill what the CRPD requires of it, and then also to leverage this toolkit so that it can accede to the secondary treaty, if you like. So this is what section 13A looks like. So Sanya and I have written a paper that will be published in a few weeks in the Constitutional Court Review that goes into a lot of detail. And one of the things we do in that paper is actually present a table that shows you where this text comes from. And the court did take from the Marrakesh Treaty. It took some a bit from Section 19D, and it did take some also some ideas or some text from the draft regulations that had been put before it by the first amicus. So this is Section 13A. I'm just going to pick up a few things. I'm mindful of time. So accessible format copy comes directly from Marrakesh. Beneficiary person comes directly from Marrakesh. What's interesting, what I should point out is down here at the bottom, when it speaks about permitted entities, Marrakesh speaks about authorized entities. And what is the reason for that? The reason for that is that the court actually did not want to craft a solution that would require another entity, another government or require further regulation or other statutory instrument to make it work. They wanted to provide an all-in-one comprehensive remedy that could be used immediately. So they chose to use the idea of permitted entity because that would be solely within their domain. And so we've got this idea of permitted entity in Section 13. The rest of Section 13A then talks about what can be done without authorization. So Sanya explained at the beginning that authorization is really the touch point. That is the thing that in many circumstances stood in the way of access, that requirement for authorization. So the rest of Section 13A is about when accessible format copies can be made without authorization. And so there are conditions for when this can be done. And so things like it's got to be non-commercial. Yes, non-commercial for non-profit reasons. It's got to be limited who can use it. It is for the benefit of beneficiary persons, people with those print and visual disabilities. And I've been showing the slide for a while, so I hope you've had a look at Section 13A, but I'm going to go past, and hopefully in the question and answer, if anyone wants to come back to the actual text, then we'll come back. But I just wanted to make the point that it borrows heavily from Marrakesh because it aligns with that fused national approach that the country wants to take. And so what does this section then mean for ongoing copyright reform? I think both Sanya and I have said this before, but I'll say it again. This case does not make any adverse finding with regard to providing exceptions and limitations for persons with other disabilities. It simply was confined to the parameters of the case before it. So the court could only make a decision based on that. And this is partly why it rejected Section 19D, because Section 19D is broader. It goes to all disabilities, but the case pleaded before the Constitutional Court pertained only to a subset. It was a narrow one. And so to use the court's own words, then it said that, and it's the last bit that I really want to talk about. So the court said it wasn't making any findings about whether or not Section 19D actually met the precepts or the requirements of Marrakesh that was beyond the court. So that is left firmly within Parliament's province. And Parliament, as you've heard, has continued to think about how it can best achieve this national fused approach that would permit the country to accede to the Marrakesh Treaty. And so this is a screen grab of the current formulation of Section 19D. Again, we don't have enough time to talk about it. Perhaps I can only make 3 points. The first that I want to make is that consistently through all the iterations of this bill, there has always been a provision that sought to create an exception and limitation for all disabilities, for all works. It has changed through the years, and this is what it looks like. So it uses the concept of an authorized entity, firmly using the Marrakesh language. You will note that if you compare this with Section 13A, Section 13A, as I explained, does not use the language of authorized entity. It used permitted entity, and I explained the reasons for that. I explained that one of the things, top of mind thoughts that the Constitutional Court dealt with was there was a need to actually have an immediately implementable solution, that no more time could be wasted to allow this inequity or this discrimination to continue. And so what this section then now does is been now crafted in a way that is not going to require any further subsidiary or standalone regulations to bring it into force. It's now been crafted in a way that would allow it to become immediately implementable once the bill goes through the processes and becomes law. So just 2 points about Section 19D. There is, of course, a lot that could be said, but time doesn't permit us. And so, Sanya, I hope I have covered a lot of ground, but also at a reasonable enough speed so that people can actually hear what I'm saying and follow. So I'm going to stop, and hopefully we have time for some engagement.
Thanks very much, Caroline. That was, I think you hit the right notes and you finished in exactly the allocated time. So we do have space and time for questions now. So I'd like to open the floor to our participants. If you have questions, either raise your hand or type out your question in the chat. And we'd be very happy either to Caroline or me or to the both of us. We'd be very happy to take them. We have a hard stop at 4 o'clock, so you've got 15 minutes to get your questions in. So I don't see any questions yet at the moment. So perhaps what we could do, Caroline, is if you don't mind putting up 19D again,
Right.
we could just take everyone through sort of what each of the parts of 19D really say. Because, you know, this might be the first time that people are actually reading 19D closely. That could be one valuable sort of takeaway. And if people have any other questions or anything, please post them in the chat or raise your hand, and we'll move to that after we go through the different parts of 19D. So Caroline, you had explained what an authorized entity was, and I think it's the previous slide.
Yes, back there.
Yeah, so if you don't mind proceeding with a sort of short explanation, then I can jump in after that. Is that,
Okay.
if that's acceptable, please go ahead.
Yes, sure. So the definitions are not here, so it just launches in and it says an authorized entity, but you know, one can simply say that authorized entities would be stakeholders or role players within this ecosystem who meet certain requirements, who then would be able to leverage exceptions and limitations. So we've got the authorized entities who then are able to rely on these exceptions and limitations. It goes on to say, or any person as may be prescribed and who serves persons with disabilities. So there is further scope here that should the need arise, should it be prudent, wise to do so, that there may be other persons who may be prescribed, to be allowed to do this if they serve persons with disabilities. So they may, without the authorization of the copyright owner, make accessible format copies for the benefit of a person with a disability. Again, maybe speaking about the broad approach, it's a disability, any disability, not the narrow toolkit approach. They may supply that AFC, accessible format copy, to a person with a disability by any means, including non-commercial lending or by digital communication by wire or wireless means. and they may undertake any intermediate steps that would allow them to do this. And whilst I'm there, I just wanted to go back to what we said earlier about the African group proposal. So one of the things that the African group put in their proposal is that, they should be focused on catering for other disabilities, but also that they should be an intentional focus also on the digital environment to make it also possible to share these format copies electronically or in the digital environment. So that's really important. And then the conditions. Sanya, if you're watching the chat, I
Yeah.
see some, tell me if I need to stop.
No,
Yeah.
not at all. They're just requests for the text of 19D, which I've shared. And
Brilliant.
Pam has kindly shared the PDF version as well, so everyone has access.
Excellent. Okay, brilliant. So these are the conditions, the 3 conditions. You must have lawful access to the copyright work or a copy of that work, really important. I think also self-explanatory. And then in converting the work to an accessible format copy, the integrity of the original work must be respected, taking due consideration of the changes needed to make the work accessible. So again, I hope that's self-explanatory. So we want to maintain integrity, but we're also alive to the fact that certain adaptations may be required to make the work accessible. And so that is going to be allowed. And I've already mentioned the non-profit. So those are the conditions, very closely aligned to Marrakesh, the same.
Sorry, Caroline, before you proceed, I see a question in the chat.
Yeah.
Shall we pause 19D
Yes,
and
we
take
can
the
do that.
question? Great.
Yeah,
So
sure.
I'm going to read it out. The question is from Subhashini Ellen, who asks for the provision of accessible content for educational purposes to our students using screen reading assistive technology. Can we, as a disability support unit, proceed with accessible content provision without the copyright holder's permission as we usually do?
Yeah. So this is asking, can we immediately leverage Section 13A?
Yeah, and in my view, look, I will say my view and then I'll hand over to you, Caroline, to also express yours. The judgment is very clear. If you read the order, it says that the whole point of having Section 13A is that it's immediately realizable. Section 13A is an immediate temporary remedy to ensure that individuals, people with visual and print disabilities, don't have to wait anymore for access. And so if so 13A, Caroline, if you don't mind pulling up, you've got it on your slide, 13A. We can look at what 13A says exactly, but in my view, it should be possible to do it immediately without permission, especially because it is directly for the use of a beneficiary person as described in 13A as well. Yeah, so number 2 there. That looks to me like a permitted entity may, without the authorization, make an accessible format copy of the work and supply those copies by any means, undertake any intermediate steps, in providing that that particular entity has lawful access. So that's the most important thing, that the work does not introduce changes outside of those that are strictly necessary to make the work accessible, that such copies are supplied exclusively to be used by beneficiary persons, not by people who are not beneficiary persons, and that this activity is undertaken on a non-profit basis. Now, the question that was asked for students from a disability support unit. So presumably it is a non-profit basis. It's exclusively for students with disabilities. And it's just a question of the technical copy, what is in the copy. Is it strict changes that are necessary for access for beneficiary persons, and then to ensure that the disability support unit's access to that work itself is lawful, and presumably if it's from a university or a school library, that is lawful access already. So it looks to me, and that's immediate because that's what 13A does. That's my view. Caroline, do you have the same view or a different view?
No, I fully agree. I'd just gone one slide before, just to say that unit definitely also falls in within the definition of permitted entity. So the answer, I think, is firmly yes.
Yeah, that's a really important point, because so if we look at the definition of permitted entity closely, it means an entity that it's an inclusive definition. So it's not a limited list there. It says government institution, non-profit organization that provides education. So this sounds very much like it falls firmly within that instructional training, adaptive reading, or information access to beneficiary persons. And that doesn't have to be on a non-profit basis, and that doesn't have to be its only activity. It's enough for that to be one of its primary activities, or an obligation imposed by the institution within which it's operating. So yeah, I mean, for anyone else who wants to actually use Section 13A, this is a really good example of what are the different parts of 13A you need to look at, and then to consider how it applies. And it applies immediately. That's both Caroline's and my view on it. Okay, great. Looks like we've answered that question. If there are any more questions. Sorry?
I see a new notification. Isn't there a new?
Oh, no, that's just the person who asked the question, Suhasini, saying thank you.
Oh, great. Oh,
You're
brilliant.
welcome.
Okay. I'm pleased. Yeah.
Yeah, so let's move then back to 19D, the second part of it.
Yeah.
Because it's helpful then for people to understand cross-border exchange as well. Or rather, we did 19D1, which basically explains what the position will be in law if this is passed for authorized entities. And then for 2, so shall I proceed with 2 and then
yes, please go ahead. Yeah.
Hand over to you again. So 2A talks specifically about someone who receives the work, the AFC accessible format copy. And that person, if that person is a person with a disability, they can reproduce the work for their personal use. So for example, if it comes on one device, they can move it to another device for their personal use. Again, remember, this is all non-commercial and not for profit. This is just for personal use. And if it's someone else, like say, for example, a friend in the library, in a fellow student in the library has a visual disability, and you also have a visual disability, then they can share it with you. Instead of your fellow student needing to make a fresh copy every time. So that would ensure that resources are not constrained. So that's what that means. So that's 1, disability for their personal use, and 2, who serves persons with disabilities, including an authorized entity, for personal use by a person with disability. And then it says specifically 2B that the provisions of this of paragraph A that we just discussed are without prejudice to any other exceptions and limitations. And that's why I gave the example of students, because there the students would potentially be exercising another exception and limitation, which is borrowing a book from the library, or borrowing an excerpt of a book from the library, rather than having to purchase commercially a new copy for every single course that they have. And then number 3 talks specifically about how a person with a disability or someone acting on their behalf, which also includes entities that like the disability support unit, etc., may make an accessible format copy where that person or otherwise may assist the person with a disability to make and use accessible format copies where the person with a disability has lawful access. So that's a very interesting provision, because what that does is it recognizes the inherent dignity and agency of people with disabilities as well. What it does is, so far we've read about people assisting people with disabilities, but this 19D3 talks about how people with disabilities themselves should be able to convert it by themselves. And that's totally possible using a screen reader, for example, for them to convert it by themselves, to have the agency to do that, and to realize their full potential and fully participate in society, rather than having to rely on other people to do it. And that really shows a sort of paradigm shift in recognizing the agency of people with disabilities. Caroline, I'm going to hand over to you for cross-border provisions. That's number 4.
Yeah. Right. Yeah. Thanks. So earlier on, I spoke about the need to be able to share materials, particularly also across borders. And the reason for that is that if you've got such a useful exception and limitation that actually allows you to do this. To then confine all such activity to within one jurisdiction really is counterproductive, because it means that here in South Africa we'll be plodding away, making all these works. Our neighboring countries are doing it, everybody is doing it. Whereas if we shared the load, then we could actually do so much more and be so much more efficient with that. And so the text then is that a person with a disability, a person who serves them, including an authorized entity, again bringing forward that that agency point, that it could be the person with a disability themselves or someone who serves them, or we could go the institutional route and it's actually a recognized stakeholder who does this on a routine basis. So all of those without authorization of the copyright owner, they may export to or import from. So it's sending the resources out and also receiving resources into the jurisdiction. And what can then be shared across borders in this way? It's any legal copy of an accessible format copy of a work for distribution. And it would be done, of course, to make it available for persons with a disability, as long as that activity, the import and export, is also done on a non-profit basis. So this is really useful. Like I've said, I mean, I cannot emphasize enough how useful it is. You've got the normal inbuilt conditions to make sure that you know, the exception is within bounds and that right holders' interests continue to be protected. So there's talk of a legal copy. It's constrained. It must also only be to make it available for persons with a disability, no other constituency. And of course, it must continue to be on a non-profit basis. So that's really useful and that's really important. And of course, in full alignment with the Marrakesh expectations. Then paragraph B, further limitation, if you like, further boundary setting. Those persons we've just spoken about, they may not engage in this cross-border exchange where they have actual knowledge, or they have a reason to know that that copy is going to be used for other purposes other than the primary and sole purpose of giving access to persons with a disability. So for A and B obviously go together, very strongly constrained, very good boundaries to make sure that the aim of the legislation is achieved without prejudice to right holders. Sanya, do you want to do 5?
Yeah, sure. I mean, we have 2 minutes to go, so I think we are ending at the right point. But yeah, number 5, sorry, Caroline. Yeah, number 5 essentially says that this entire exception is subject to the obligation that people who are making such copies and sharing such copies have to indicate the source and the name of the author if it appears on the work in any copy that they make. Now, that's something that, as I talked about at the very beginning, there are 2 sets of rights that fall within copyright: the moral rights and the moral and material interests of copyright holders. And this speaks then to the moral interests, because what that does is it speaks directly to the right to attribution, where authors have a right to be attributed to any work that they have authored. So this ensures that the moral rights of authors continue to remain protected, even in an accessible format copy. So people can't pass it off as their own. It's very clear. And in any event, as I said before, it's a shift in the format. So where the author's name appears in the original text, then the format shift should include that where practicable. So yeah, I think that actually brings us very nicely to the end of our webinar today. I'd just like to say thank you to Caroline for joining us today. I think it was a really informative webinar, and it is always a pleasure to work with you. I also want to say thank you to our audience and to the organizing staff, Magda and Tanya from the MI and from PIGIP, for putting this webinar together. Thank you, everyone, and we'll see you for the next one, which will take place next week. Look out for the advertisement. Bye, everyone. I'm going to end the meeting now. Thank you.
Thank you. Bye.